My baby dolls, we are back again, another episode of Genesis. As always, I am your host, Ian Kahanowitz. And today we're getting two loves of what I love in life, and these are my passions besides history. We got baseball, and we got law. And most of you do know I usually speak about my court cases and my cases I'm handling for tax and other goodies, and today we have a book that I suggest everyone go out and get and keep it on your reference desk or in your library. It's called Baseball Meets the Law, a Chronology of Decisions, Statutes, and Other Legal Events, written by two distinguished professors, and we'll go into their bios before we bring them on the show, Edmonds and Frank G. And what I love about this book is it talks about everything. It talks about reserve clause. It goes back to the 1700s. It goes through the whole Players Association and the whole outlaw leagues in the late 1880s, 1890s, the player leagues. We're getting the Landis decision on Federal League Baseball. We're going through 1922, the whole antitrust thing. Does it applicable? Does it apply? We are going through the Black Sox case and why Landis threw them out, even though a court of law exonerated them. Man, I got such a show for you folks today. You're going to learn a heck of a lot, like you do with all my shows, and normally I do baseball history, obscure stuff. And let me tell you something. This stuff is obscure, but it's important to know because it creates the whole image of what we have today in baseball. But you are listening to the Comfortably Zone Radio Network. And, of course, our fearless leader, Ralph Tycho, does the show out of Alameda. He gets my show as soon as I get off the air. He gets the show. He puts in the bells and whistles and whatever, and it gets published in a week or so. And I'm honored to be on the network. We got Peter Golenbach and Golenbach's University. We got Golenbach and Hal Bach, AP reporter for almost 60 years. He's on a show for Vintage Sports. We got Bill Kashatis, who is huge down in Philadelphia. We got Philadelphia baseball. We got Charlie O's niece, Nancy Finley, on Oakland A's baseball. We got Dave Nemec and Alan Blumkin on Dave Nemec's old-time baseball and trivia. And normally I'm on that show, but I got two monkeys I call twin boys running around at 9 years old. And unfortunately, I got to take them to football practice and baseball practice, and I'm running around, and I can't make the show on a Thursday at 4 o'clock in the afternoon. But these guys are retired, and so they don't have any kids they got to worry about, and they're free to do what they want. So I'll probably be on once November comes and the Christmas season starts and the holiday season. I don't know. We got to be politically correct these days. But we're going to get back onto that show. There's a lot of baseball, folks. There's a lot of stuff going on. The playoffs are near. My Yankees have gotten in. The Red Sox, where I live up here, are in. You got Houston. You're going to have Minnesota. You got a runaway Cleveland team. You got the Dodgers out in the west of the sputtering. You got Arizona, Colorado. You got Washington, and you got the Cubbies again, all fighting for, going to be fighting the ALDS and NLDS. But of course, we got that silly game wild card, which I'm totally against. I love how they just break the rules, Major League Baseball, just to get money. But that's another story, and we're going to be turning to this book, Baseball Meets the Law. And I just want to read an excerpt because we had a nice gentleman early in the year. We had Mitchell Nathanson and his book on Dick Allen. And I'm going to quote right from his review about the authors. Edmonds and Hodek have produced a book that will no doubt be an invaluable starting point for any researcher seeking greater insight with regard to any of the nearly 400, listen to that, folks, 400 accounts of referenced in here. And so we're going to go, baseball on Sunday. I mean, they take it to a level where, if you never knew any of this stuff, you're going to be learning a lot of stuff from this wonderfully written book. And, of course, Mitchell Nathanson, he is in Villanova Law School, and he's a member of SABR, and he did God Almighty himself. He loved the podcast. As for Ed Edmonds, He's an emeritus professor at the Notre Dame Law School. See, all the big shots come from Notre Dame, and most of you know I'm writing the book on Ty Cobb and Trispika. And do you know Notre Dame was so helpful to get me the transcript of Smokey Joe Wood, what he talked about of gambling. That was the unpublished stuff that he asked Lawrence Ritter in The Glory of Their Times never to publish. And I got it sitting on my computer as one of the primary resources that I'm using for my book. And he retired in 2016, having served as the law library director at William and Mary Loyola, New Orleans, St. Thomas, and Notre Dame. He has written numerous articles on baseball and antitrust and labor law issues. Now, Frank Hodak is an emeritus professor at the Southern Illinois University School of Law. After serving for 30 years as law library director, professor of law, and associate dean for academic affairs at SIU, he retired in 2014. Since then, he has pursued his research and writing interests in both baseball and the law. And let me tell you something, folks. If you ever want to sit in a law school class and actually see what goes on, normally traditional methods is what's called the Socratic method. And you're going back to ancient Greek times where Socrates did not believe in lecturing, he believed in interaction. And so every day you have to go to class with briefs, you read these cases, try to get what's on there. They'd stand you up, scare you half to death in front of the 300 other law students waiting to be scared half to death. Recite the case, recite the rule. It's called IRAC, and it's not the country, it's issue, rule, application, and conclusion. And we're going to have something similar on the show. Welcome to the show, gentlemen. How are you?
Very good. Great to be here.
Yeah, we're not going to go through that IRAC process, because that thing. Do you realize after 20 years of graduating law school, I'm still briefing cases with the yellow marker, the pink marker, the blue marker, and the green marker, all standing for a yellow issue. Red is the issue. Blue is the final thing, and green is the analysis. So I got my own stuff going. Let's talk about the baseball rule and what happened to that little girl last week. Who wants to start?
Well, I'll be happy to weigh in on that because I was fortunate enough to kind of be contacted about the baseball rule. The baseball rule basically says that as long as the owner of a stadium screens the area most proximate to home plate where there's the biggest possibility of an injury, that absolves them of any responsibility for injuries from foul balls, from flying bats, from thrown balls. And the idea is based on the old negligence concept that you assume the risk of any of those kind of injuries, and so as long as you've maintained that screen properly, then that's going to be fine. So the little girl was hit by a line drive off the bat of Todd Frazier down kind of the left field line. So she was a little bit beyond the dugout down that line, and what I've advocated for and what it looks like now this incident may help push forward is that instead of just screening the area from the home plate side of each dugout, that you actually screen at least as far as the end of the dugout, usually down the first and third base line.
Well, let me ask you this question. Now, Ed was quoted by the New York Times, Washington Post. I saw the article. Let me ask you this. Doesn't the concepts of licensee and invitee apply here?
Well, I think they do. The doctrine is still based on a fairly long-standing tradition of baseball rule, and we mentioned some of those cases go back early in the 20th century, and there have been so many cases brought about this, and so the invitee and that aspect goes back many years as well to this idea of assumption of risk. One of the things that I think is interesting that has changed is that most jurisdictions have adopted either legislatively or by court decision some form of comparative negligence, which would weigh the balance. It's kind of a balancing test between which side has certain degree of fault, because assumption of risk, if there's 1% fault, then you lose entirely. So that, I think, has begun to cause some courts to look at the baseball rule and say that it needs to be considered differently from this kind of longstanding complete bar for any plaintiff who gets injured. And there have been some pretty severe injuries, including the gentleman at Yankee Stadium who lost an eye after getting hit by a foul ball.
Sam, let's define a couple of terms here, because we're lawyers, we understand this. Let's get into what's a licensee, what's an invitee, what's contributory negligence, and what's comparative negligence. I'll let any one of you get into that.
Keep going ahead, Ed. I'm thinking about
comparative negligence. As you mentioned, I spent some time in Louisiana, which still has a lot of its civil law heritage. And the example I tend to use in class is that comparative negligence, which is this balancing test between faults in a tort action. The example I often give has to do with ships at sea, because for years collisions at sea have been controlled by comparative negligence and civil law kind of tradition. And so they would look at the facts as they can figure them out and say, well, this ship was 60% at fault, this ship was 40% at fault, so the one with less fault gets that differential in terms of a recovery. So a number of jurisdictions, because contributory negligence, which is a doctrine that says that, if the plaintiff brings a lawsuit and the defendant says, well, but you did something that actually caused some of this harm to happen, that was a complete bar. Assumption of risk, which is typically what's cited in these baseball foul ball cases, says, you assume when you come into the stadium that you assume that risk. And in fact, for years they would put a waiver on the ticket that says you assume the risk when you come into the stadium for any of those injuries.
Now, the thing is, I think in comparative negligence, one of them has a 50% or greater. If you're 50% or greater, you're liable. But the other one has a percentage. Like if you're 10% negligent, you could still win off of that 10%. Which one is it? Is it contributory negligence or comparative negligence? I forget.
Well, comparative negligence is usually assigning a percentage of fault. And in the pure kind of civil law systems, that's the way they function. Here in the United States, it's had a lot more to do with the damages part than actually kind of the breach of duty part to bring back those things that terrified first-year law students, as you mentioned, in a Socratic method process.
Yeah. Now let me ask you this. If we do institute something like this, you have many jurisdictions in baseball. Each are different. Some of them still follow contributory negligence. Some still follow comparative. How do you weigh damages for somebody being hit with a foul ball?
Well, I think that can be problematic. My response that I've come up with over the last year, I guess, is that perhaps we should look at something more like a workers' compensation system, where all the team owners in Major League Baseball pay into a fund, and you certainly would be able to then cover the medical expenses and some aspect of the life-altering injury that some fans receive from being hit by a foul ball.
Well, let me ask you this also. You mentioned a guideline earlier when we were talking that you think that should be put down, past the dugouts and stuff. But a possibility of a fly ball over the wall into the bleacher seats can still knock someone in the face if they're not paying attention. Why not go out there? Is it more dangerous to be out there in the bleachers than it is, say, in left field, second deck? I mean, we know first base and third base, you're sitting on ground level, there's a possibility of getting hit. So pretty much, yeah, you know you're there. You got to assume the risk. But what's the difference of being in an upper deck in left field with a foul ball that's going to hit you, or being over the wall over there that's going to hit you? Shouldn't we net the whole stadium in that case?
Well, I think at this point, I'm interested in at least incremental progress, and I think the chances of a severe injury in the outfield are much less. However, one of the cases, Edward C. case out in New Mexico, where a young toddler was hit by a home run hit in batting practice, was severely injured. His skull was cracked. So a very tragic situation. And he was in the outfield in kind of a picnic area in Albuquerque at their stadium. So it is certainly something that could be looked at. The biggest pushback has been that fans like to be able to jostle for foul balls, and they like, now that Major League Baseball throws almost every ball out of play, they flip balls to the fans and things like that, and that's been the big pushback. So I would at least like to see some balance. Those areas, like where Todd Frazier's ball hit that little girl in Yankee Stadium, the speed off the bat's 100 miles an hour. Most fans, even pitchers, get hit by line drives, can't react quickly enough to that. So let's start by at least doing something for those areas.
Get it.
One of the things that we covered in our book are a couple of cases that even before this went against baseball rules. Even baseball rules, they involved activities by mascots, and which caused injury. And courts ultimately found that maybe you would assume the risk of getting hit by a foul ball, but you don't assume the risk of being distracted by the dinosaur mascot of the Cucamonga Quakes tapping you on the back, causing you to turn around and then miss the flight of the ball coming in and hitting the individual in the eye. A similar case in Kansas City where the Kansas City mascot for many years had shot hot dogs into the stands. And once again, courts ultimately held that maybe you assume the risk of getting hit by a foul ball, but not by a flying hot dog shot out of a cannon by a mascot.
Well,
so there's already been
cases.
Already been some cases which have dug into the baseball rule and carved out some exceptions.
Well, let me ask you this. Now, I remember growing up in New York in the 1970s. They always had Bat Day. Remember that? Bat Day? Did they have it out?
Yes.
Yeah, Bat Day. Okay, fine. All the fans under 14 get bats, but these morons sell alcohol at the same time? Boy, that's real smart. Now you're giving them a weapon to people, and you're going to slug the guy next to you if he's rooting for the other team. If you get inebriated at the park, how can you pay attention to a foul ball?
Well, that I think is part of why it's probably worth reconsidering the whole scope of the baseball rule. Notice they have made some changes about selling alcohol, so they stop in the seventh inning and some things like that. But the baseball rule goes so far back in time, not that drinking wasn't important. In fact, my favorite team, the Cincinnati Reds, were thrown out of the National League because they wanted to play baseball on Sunday and serve alcohol. So that goes back to the 19th century.
You know, I had a show on the beer and whiskey leagues in the early 1880s with the St. Louis team, and the owner, I forget his name now, part of the reasons why he invested in them.
Bondurant.
Yeah. was to get his beer company going. I think Rupert did the same thing. Jacob Rupert with the New York Yankees, you know, he bought the Yankees thinking he could sell more. But now this brings us to another category, okay? Let's talk about Sunday in baseball, okay? Because the blue laws even applied in Massachusetts when I moved up here in 1993. You can't buy alcohol before noon. You can't play baseball. That was ruled long ago. But what was going on in the 19th century with this Sunday baseball stuff?
It was the standard rule. It had been there for a long time. Frequently, this was most often this was statute. So our book covers case law, but also covers statutory law. That is, laws enacted by both the federal and state governments. And in many states and cities, there were statutes which prohibited not only baseball but lots of different activities, and this was when Sunday was considered a special day for rest and not to be doing other things. Of course, the challenge was that they played baseball during the week when most people were working. In fact, there were 6-day work weeks, and so for many people, the only day they could go to a baseball game was on Sunday. So gradually and very, very slowly, the statutes were amended or repealed, and frequently what happened was on the state level they would change the law to say that local jurisdictions would have the option to allow playing of baseball and other activities if they chose to pass an ordinance which allowed it. So the state would allow a local jurisdiction to make that decision. It was sort of avoiding the political consequences of on a state level saying we're going to remove that restriction and allowing it to occur on the local level. And so we cover a number of cases involving the enforcement or lack of enforcement of these rules. One of the ones, correct me if I get this wrong, Ed, case out of Ohio, where once again there was a state law which restricted or prevented playing on Sundays, and the Cleveland owner decided to move their games away from the main stadium in downtown Cleveland out to the outskirts, I think. Is that right, Ed? Am I remembering that?
Right. It was a suburb that was kind of I think it was an unincorporated association development east of Cleveland.
Yeah, and then nevertheless, they did enforce the law there, and as I recall, they arrested all of the players and the manager, and then they eventually charged the young rookie pitcher, I believe.
Right. The pitcher got.
Yeah. So a lot of interesting stories about that. The last major league city to finally play a legal Sunday game was in Philadelphia, and Connie Mack had tried to get that law changed for probably 2 decades because for him it was very important to be able to Sunday was going to be a day where you get a lot of fans in the park. So he had tried very hard to make that happen, and finally he did. But it was in the 1930s, if I'm remembering correctly, that was they finally played that first legal Sunday game in Philadelphia.
Now, it's interesting, and we're going to get into the gentleman's agreement. We're going to segue into this from this. But if you recall in the 1930s, and you guys were around when Sandy Koufax refused to pitch in the World Series on Yom Kippur.
Oh, yeah.
I wasn't
Absolutely.
around. I came in 1970. Sandy retired.
I was there. I'm a Dodger fan. I'm a big Koufax fan. I have pictures of him in my office.
See? So, Sandy, he wasn't going to pitch on Yom Kippur. But, back in the 1930s, Hank Greenberg, it was going to be Rosh Hashanah, and the Detroit Tigers were in the pennant race and all this in 1934. and he actually had to go to rabbis to see if he could play on Rosh Hashanah, and they said, yeah, there should be no law. But baseball did not give deference to women, to blacks, to Jews. It was this Sunday thing, and it struck me like, well, yeah, it's the Lord's Day, of course. You know, we are in Christian America. You got a lot of Irish in the baseball. David Fleitz wrote a book on the Irish in baseball, pretty much 19th century stuff. And yeah, so they're doing that. But you know, blacks were allowed in baseball prior to 1887. Women, the game was designed with women in mind because the original baseball was done for exercise. And, of course, it wasn't until the 1880s where you had this growing anti-women, anti-Semitism, anti-black. You can't play. Of course, Cap Anson was pretty much, we remember him for the gentleman's agreement. There's never been a written agreement, but let's describe what was going on in the 1880s and what is the gentleman's agreement here.
Yeah, so unfortunately, Cap Anson has a connection to Notre Dame, and it was his refusal to play a team that had an African American player on it that had a lot to do with the start of all of that. And yes, there were players, there were African American players even at the major league level in the 19th century, but I guess we could look to the post-Reconstruction era and say that after those kind of post-Civil War changes, that there was this rise in segregating the game, and that agreement was, as we mentioned, that even in the introduction of the book, a lot of this was indeed custom as opposed to actual laws on the books. Judge Landis often said that there was no restriction in the Major League Baseball rules, but as far as any of the historians I've read can tell, Landis was absolutely opposed to Major League Baseball opening up to black players, and in fact, Jackie Robinson's debut came a year or so after Judge Landis passed away, and Happy Chandler was commissioner. So that became an entrenched rule that African Americans couldn't play at the major league level, and so you had the development, or at the minor league level for that matter. You had the development of a separate Negro leagues, which was actually a thriving, important business with many African American entrepreneurs running those businesses in segregated areas of the South, and certainly this impacted the North as well, where Major League Baseball and the minor leagues did not have any African American players, so you had two separate operations.
Now, let me just
one thing I just want to toss in here that we're talking about these extra legal rules that were very rigidly enforced, but there were, not at the major league level, but there were a few states in the 1950s that actually passed laws that restricted, that said you could not have blacks and whites playing on the same field, and that we document. We have a couple of cases in our book which go over the consequences of that and the challenges that those ultimately face, those laws face. But these were actual statutes. It was beyond. It was more than just the gentleman's rule. And these were statutes that were enacted after Jackie Robinson broke the color line in Major League Baseball. So they occurred in the South, not in the northern states, but in the South. But there were actual statutes. The other thing I wanted to mention about the beginnings of this in the 19th century, we, I think, rightfully think about the extreme prejudice that existed, and that is the central focus behind the prevention of African Americans playing in organized baseball leagues until they organize their own. But I think another aspect that has to be at least acknowledged and recognized is that this was also an economic issue. I mean, major league jobs were relatively scarce. And if you can cut out a whole class of people who might be well qualified for those jobs, but you're not going to allow them to compete for them, that means you're opening up jobs for whites. And I think that was a factor as well. It's not usually referenced, but it certainly existed, and for well into the 20th century as well.
Let me jump back in and add something. When I was down in Louisiana, I did some research. I've got an unfinished manuscript somewhere on the anti-mixing law that was passed in Louisiana. And they had a fairly thriving team in New Orleans that had a segregated section for blacks. So you had segregated seating sections in the stands. And when they passed the anti-mixing law, which forbid African Americans and whites from playing any kind of sports against each other, they created a boycott. African Americans in New Orleans boycotted the New Orleans Pelicans games. That ultimately they put enough economic pressure on that franchise dissolved. So Frank's exactly right. There were, after Jackie Robinson broke the color barrier, a lot of states and in sometimes municipalities in southern states passed anti-mixing laws, and so they did put what had been Jim Crow customary laws on the books in those states.
And you know what's interesting about this? Because when Jackie broke the color barrier, and you had Larry Doby, it was mainly National League teams that picked up on the African American Negro League players. The Negro Leagues started to die. Their businesses, pretty much, the Negro Leagues were so essential to businesses in the African American communities. It was church, it was work, and it was baseball for these folks. And now you're getting jurisdictions coming back in a repressive form saying there's not going to be this is the whole thing with the Civil Rights era. We're going to keep Negroes out. That's it. But what I do want to say, there was an obscure law in New York that not a lot of people knew about. I think it happened right after the war in 1945. Again, you both know about Woodrow Wilson letting separate but equal happen in the workplace, in federal workplaces. And so in 1945, what happened was New York State passed a law integrating workplaces, business places. Branch Rickey saw it as a thing. I can now try to find the guy to put on to the Dodgers. Did you guys hear about that?
Yes, there was. I know of a New York City ordinance that was very prominently used in the black press to move for the integration of baseball, and it was very much at the core of the conversation about the fact that the Yankees, the Dodgers, the Giants were in violation of that ordinance in New York.
Now, my thing is with Landis, a lot of people will say Landis was racist, he was sexist when, what's her name, struck out Babe Ruth and Luke Jordan. They were Jackie Mitchell, I think her name was. They were ready
Jackie Mitchell, right.
Yeah, they were ready to give her a contract. Landis said, the hell with that, But I think Ford Frick, when he was commissioner, said there will never be any women in baseball. It was never written, but he said it. And it closed the door on women, and women's rights are...
Well, there was actually a woman, Engel, I forget her first name, who signed a minor league contract in about 1952, and that's when that Ford Frick said that. Basically, they nullified the contract and said, and by the way, that women will never play baseball. Yeah,
now,
that's an interesting case we cover.
Now, I had Isla Borders on my show in May. She was the first woman to have a minor league contract. And, of course, Bill Veck's son was the one who hired her for the St. Paul Gophers back in 1990. Oh, I'd say 8. Well, anyway, she was on my show, and she told me about all that stuff that was going on. And, of course, I champion women's rights. I have a Women in History.
Sure.
Right? But let me just say this about what went on with Landis, because we'll talk about Bill Veck for a second, father. He wanted to buy the Philadelphia Phillies in 1943 during the war. Everyone was out, stars, and he wanted to house the team with mainly Negro League players, thinking, well, they can play. Landis nixed the deal, but what many people don't know is that Landis was looking into the possibility of integration and how it would do for business in baseball when he suddenly died in November of 1944. So his prior dealings with the African American communities, he has a checkered history. But he did have the fact that was on the books, that was on the boiler, and he was looking into if something like that could occur. Of course, he died prior to it, and Happy Chandler took the race. So let me ask you about Happy Chandler, because now we have something called the Mexican League down there, don't we? And if any one of you ball players, because the Mexican League was stealing Negro League players, and they were stealing Major League Baseball players, there was no reserve clause down there. And those guys were paying nice amounts of money to these guys to lure them away. If you go down there, you're going to be barred from baseball for 2 or 3 years. Let's talk about that.
Well, the most celebrated part that we kind of cover involves Danny Gardella. Danny Gardella played for the New York Giants during World War II, and largely because he worked in the defense industry in the port of New York in that area, and so he had a deferment from going into the military. And a lot of players, of course, went into the service during World War II and depleted the number of available players for Major League Baseball. And so he went down to Mexico largely after going to spring training when the veterans all returned and figuring out, well, I don't have much of a chance of making the Giants anymore. So he went along with Max Lanier and a few other players down to Mexico, and as you said, they were blacklisted from baseball. And he came back and sued Major League Baseball, and actually the case got to the Second Circuit, where the Second Circuit in a 2-1 split said that Gardella, that the baseball's longstanding exemption from antitrust law, the Second Circuit kind of gave him the opportunity to go back and try this case. He settled.
They were pretty strong, saying they thought that federal baseball was wrongly decided. I think Second Circuit.
Right.
And so it looked like
that's right. In fact, I think it was Learned Hand who called it an impotent zombie, the federal baseball decision. So one of the great use of phrases in judicial decisions. Judges get outside of their normal comfort zone when they have baseball cases, so they come up with some interesting comments. It was either Judge Frank or Judge Hand. They both wrote opinions in that case, but that's right. And that, I think, is what emboldened Frederick Johnson was the attorney on the Gardella case, and kind of, I think, emboldened a number of lawsuits that then made their way up to the U.S. Supreme Court in the Toulson decision. Earl Toulson was the plaintiff of one of the 3 cases that the U.S. Supreme Court took. And actually, the importance of the Toulson case, which is largely overlooked, is it really cemented baseball's antitrust exemption by basically in a short per curiam decision saying federal baseball exemption has been around for quite a while. Congress has failed to do anything about it, and so we're going to adhere to that without looking into the underlying aspects of the federal baseball decision.
I think just to finish the story on Gardella, unfortunately, Gardella eventually settled out of court for a lot of money, and therefore the issue never got taken all the way up to the Supreme Court. It might have been interesting to see what would have happened at that point had that, because it had been so heavily attacked by the Second Circuit, but that didn't occur because Gardella settled.
Interesting. Well, let me tell you guys something. Whenever a court doesn't want to handle something, they always say, "We'll let Congress deal with it." Okay, that's what they do with tax, notoriously. So now let's take the trifecta here. Okay, guys, let's take the trifecta. Since you brought up the Toulson case, and that was in '52, we're going to have to step back. We're going to have to define what the reserve clause was, why it was put into baseball, and why the early courts ruled against it. Frank, take it away. Either one of you.
Well, let me start kind of back at the beginning. Yeah. This was something that I referred to as Arthur Sodden's legacy, and in a piece that I wrote, Arthur Sodden, who was a Boston owner, got very upset when a couple of his major players, Porter, Rourke, and one of the Wright brothers, not those flight fame, but of baseball fame, revolved, as they used the term in those days, or jumped to the Providence Grays from his Boston team. And so he got all the owners to agree, we're going to have a reserve system. And initially it covered 5 players. And the idea was that the team had the right to reserve the services of those players for the year that the contract covered, plus the following year. By expansion of that, ultimately it covered all the players on the team. And they basically made it a perpetual reserve clause by enforcing a rule that said you couldn't play each year unless you'd signed a new contract. And so the new contract covered the year in question and the following year. So it essentially became perpetual by the implementation of a number of rules, and then Major League Baseball teams would file a list of all the players that they reserved, which would be another layer in this entire system that basically meant you were beholden to the one team that had your contractual rights in perpetuity. So
I just want to toss in to demonstrate just how awful this rule was. Initially, under Sodden's plan, the players weren't even informed that they had been reserved. They only would find out when no one else would sign them. So it was a secret reserve. It wasn't even later on they would publish the list, but initially it was a secret reserve system. This was in 1879. Sorry to interrupt, but I think it was just an interesting aspect that about the very first reserve system that was established.
And so one of the things that we see in the book is that this typically would become an issue when there were upstart leagues. So in the 19th century, there were a number of leagues that tried to compete against the National League, which was the dominant major league during that period. And then the American League and the National League in the early part of the 20th century, basically 1901 to 1903, had a number of cases go to court, including one involving Napoleon Lajoie that I just taught about last week in class. And basically there, Lajoie had jumped from the Phillies to the Athletics, and so they went into court and actually had an interesting colloquy about whether Napoleon Lajoie was a unique enough player so that you could force him to either play for the Phillies or not play for the Athletics. And so Lajoie lost that case, but he managed to hook on with the team in Ohio and Cleveland, and Cleveland refused to enforce a Pennsylvania injunction. And so all he had to worry about was making sure that he didn't show up in the state of Pennsylvania when the Broncos, the Cleveland Broncos, that was their nickname at the time, came to play the Athletics. And so they just sent him over to Atlantic City, and he took a little vacation for those days. So by 1903, the two leagues agreed that the American League could have the same status as the National League, adopted a World Series, which, of course, is a very important aspect of the economic model of baseball. And then the next big thing would be the federal baseball suit, because the Federal League tried for a couple of years to compete against now the American League and the National League. And actually, there were split decisions in those cases. Armando Marsans lost his case. He was a player on the Cincinnati team, and they basically sat on the final decision on a permanent injunction for about a year and a half, so he lost some very valuable time playing Major League Baseball. And then we could talk, if you want to, about how Landis gets involved in that in the mid part of the teens.
But I'll tell you what. Let's step back a little bit even before that. Because we're going to get to federal baseball, we're going to get to Toulson, we're going to get to Kurt Flood, we're going to do the trifecta, and then we're going to do in 1998 the Kurt Flood Act. But let me just say this. Frank, you want to define for us what the Sherman Antitrust Act was about?
Well, I'll let Ed take that one. He's going to be better at it than me.
Good.
So the Sherman Antitrust Act was passed in 1890, and under Section 1, which is where most of these actions are involved, it says, so there are three elements: every contract, combination, or conspiracy. So Section 1 involves restraints of trade, so you have to have multiple actors, so you have to have that kind of setup. So the first element is every contract, combination, or conspiracy. In restraint of trade, and very early on they decided that meant unreasonable restraint of trade, because every contract restrains trade. And then the third element is among the several states, so it has to involve interstate commerce. So the three elements: every contract, combination, or conspiracy that restrains trade and is involved in interstate commerce.
Now, together with the Reserve Clause, we go to 1916. And let me just give you a background before we get into Landis. During the day, there were two formulations of philosophy on jurists. Okay, one of them was called legal realism, which was up and coming at the time, around the time that Judge Landis became a judge in 1905. Basically, what it said was legal realists don't look at just the letter of the law. They're not strict constructionalists. They are loose constructionalists, which means they will take public opinion, they will take the media, and they will try to fit the law in a square peg into a round hole if necessary, to achieve this justification of what's called legal realism. Legal formation, on the other hand, is, well, it was like Justice Black. He carried around a dog-eared copy of the Constitution in his pocket, even when he was on the bench from 1937 to 1971. They'd ask him a question, they'd say, Judge, and he'd look it up. If it's not in here, it doesn't apply. So you had two different philosophies. Now, Landis came on at a time, and again, Theodore Roosevelt was president. You had all these antitrust litigation going on, and everyone was busting the trust. And if you look at Landis's cases, up until the time of Federal League baseball, he voted for the little guy. He threw the book at Rockefeller saying, you guys are creating rebates. You're violating the antitrust laws. We're going to fine you $39 million. He found it in the railroad cases. He found it in other case laws that came to his desk. But when it came to baseball, his legal realism took over. The popular sentiment at the day, he loved baseball. He loved the institution. And he saw the Federal League as an outlaw league. The case comes to his desk, and I'll let one of you guys take it from there.
Well, he had a trial in January,
4-day hearing,
before the major season, the second Federal League season. So this antitrust lawsuit was filed between the first year of the Federal League and the second year of the Federal League. And so he had a trial in January and then sat on the opinion for the entire year because from a legal standpoint, he felt that Major League Baseball was violating the antitrust laws, but he loved baseball, as you said, and he wasn't going, anything that strikes at the great national game is something that he didn't want to have to ratify. So then at the end of that year, the Federal League, they reach a peace agreement, and the league goes out of existence except for the Baltimore team.
His language that we quote in one of our entries in the book is when he finally explains why he sat on the case, he said he would have been compelled to find in favor of the Federal League an outcome that, quote, would have been, if not destructive, vitally injurious to the subject matter of the litigation, i.e. organized baseball. So instead he chose to postpone until parties were economics forced them to negotiate a settlement, which they ultimately did in the early part of 1916.
And do you see how Landis used public opinion and, sentiment of what he felt to postpone his, because he didn't want to rule on it. He ruled for the little guy. The Federal League, he would have. He's like, but he did the same thing 10 years later. We'll get to that, if not this show, next show. But now, this comes to the Supreme Court. Now, this really irks me because I have so much respect for both Brandeis and Holmes. And, of course, they sat on a court which later would give Roosevelt grief. They were called the Four Horsemen. I think it was Sutherland, what's his name? McReynolds was one of the nastiest justices ever to serve. He refused to talk to Cardozo and Brandeis because they were Jewish, but yet he left all his fortune to a boys' home, So it's weird with these guys. And then they had William Devanter and you had one more, Pierce Butler. They were called the Four Horsemen, and they would literally change the face of the court in the 1920s. The more Commerce Clause cases came to them. Now, this goes to the Supreme Court. Judge Kozinski explained the reasoning behind the court's decision. Baseball is not interstate commerce. They said courts didn't assume that almost every economic activity was within federal jurisdiction. I find that hard to believe, especially when you have different cities regarding going and playing and their money making. What's the story with this?
Well, to mention again the three elements, there's one aspect of Holmes's decision that's largely ignored, and that is the second element, restraining trade. Because in his opinion, he said, baseball would not be called trade or commerce in the commonly accepted use of those terms. That's a quote. Personal effort, not related to production, is not a subject of commerce. And actually, in 1922, that was a fairly common view that it had to be the manufacturing of goods or production of goods that were covered by the Sherman and the Clayton Act, which was passed in 1914. But then, to kind of compound that, they said, it's not involved in interstate commerce. And we mentioned that George Wharton Pepper, who represented Major League Baseball, argued very strongly before the Supreme Court this view that personal effort isn't a subject of commerce. So when I teach the case, I talk about the fact that both the second and the third element are problematic there. But of course, the view of both commerce and interstate commerce changes dramatically by the time the case gets to the Gardella case or to the Earl Toulson case and Kowalski and Corbett, those three cases that get to the U.S. Supreme Court. But so Holmes is given a lot of grief over his decision, but a number of people that have looked at the context of 1922 have said the opinion isn't as bad in terms of the jurisprudence of the 1920s as later people would make it out to be.
And you know something? Okay. The sentiment changes by the end of the decade. Okay? At the time,
right.
At the time, it's the view, okay? It's the view probably in the 1870s that racism and Jim Crow, the whole backlash to Reconstruction, okay, Cap Anson, fine. And we live in a world now that's politically correct. You could have seen it yesterday at all the football games, which, again, I don't know why. It's the main news. You turn on it, today in Miami, some people didn't even come out of the locker. Who cares, okay? The law says you should worship the flag. This is how you should. Doesn't say must. So to me, this is a moot issue. It's all about patriotism, but it was all about racism, and it was all about saving baseball in the teens and in the 20s. But now look at this. Now we have 30 years later. When you mentioned Tilson versus the New York Yankees. Now look at this. The whole thing has changed. Commerce has changed. The Supreme Court affirmed the baseball, but now on a different ground. They didn't want to go there. Court recognized, the Commerce Clause reasoning no longer applied. That's fine, it's outdated, the Federal League thing. But said, hey, you know what? The federal baseball governing law, that the federal antitrust laws don't apply to baseball, hey, we can't do anything about it. Congress, here's your show. You know? So that's what you want. I don't want to touch this case and open up a can of worms. Hey, all these guys don't want to take the plunge. And the plunge comes again. The plunge comes again in 1970 with Mr. Kurt Flood. And this is very interesting because now you have an ex-Supreme Court justice, who's one of my favorite, Arthur Goldberg. He was on the Warren Court. He was probably one of the most liberal on the Warren Court. I think he was there for, a year or two, 3? I forget. He's representing Kurt Flood with Marvin Miller in the background. Which one of you boys want to take that one?
Well, I can jump in on Kurt Flood, and you're right, Arthur Goldberg. But Arthur Goldberg was distracted during all of this because he had told Marvin Miller that he wasn't going to run for governor in New York, but he later decided to do that. So a lot of his attention was there. But and Goldberg's oral argument is fairly weak. You can listen to it or read it, and it ultimately comes down to a 5-3 decision. And Blackman is given the honor of writing the opinion, which he's very excited about because he's a huge baseball fan, and he regularly has the baseball encyclopedia in his chambers close at hand. So he sits down and makes up a list of very favorite players of his that have played the game. And so you don't have to read the opinion into it too long before you realize that Kurt Flood's likely to lose this case, and a reserve clause is going to be reinforced once again. But Flood was just very upset about being traded from St. Louis to Philadelphia. Philadelphia didn't have a great reputation of being open to black players. I'm certain something that came up in your conversation with Mitchell Nathanson about his book about Dick Allen. And Kurt Flood had businesses in St. Louis. He used to have a photography business that did high school yearbook pictures, and he also did portraits and whatnot. So he didn't want to go to Philadelphia. Felt that he should be given an opportunity as a longtime veteran and celebrated center fielder for the Cardinals over most of the 1960s. That he should have the right to become a free agent. Bowie Kuhn turned that down, and then the case gets to the Supreme Court, and they basically say, well, again, they say, Congress had this under consideration, and I'm not sure the justices reviewed what Congress had actually been doing in any great detail because they had considered over 100 statutes. But of course, the other interesting thing is they say, well, we dealt with the legitimate theater in the Schubert case. We dealt with the National Football League in the Radovich case. We dealt with the Spencer Haywood case in the NBA, and we said all those sports in legitimate theater are subject to the antitrust laws. But baseball, as Justice Blackmun said, is an anomaly, and we're going to maintain that anomaly. And under the concept of stare decisis, we're going to say that even though now we'll rule that Major League Baseball is involved in interstate commerce, the exemption is still alive and well and protects baseball from any antitrust challenge.
And I'm going to throw in something here. When the drafts were sent around on the opinion, because for those who don't know, the Supreme Court, before they issue the opinions, the person that's picked by the Chief Justice to write the majority opinion or the dissenting opinion, they literally run drafts amongst their brethren. When Thurgood Marshall got when the Blackmun's draft, he goes in, he's like, well, you're signing Ted Williams and Babe Ruth. There's no Jackie around. There's no African-American. He had to revise his stuff and add the African-American players in there into his final opinion because Marshall was pissed off that there was no African-Americans named as the players that he was naming Blackmun. And, it's interesting at the same time, around the same time, he was picked to do the Roe versus Wade case, which he was very scared to do. There's a whole book written about that, and of course you could read The Brethren. I forgot who wrote the book. It was published in the 1970s about what the court does, and you have an
Woodward and Bernstein.
Woodward.
Yeah, Woodward, and he shows how sick Douglas was at the time, but yet he was still effective even in lobbying. Now, Congress did act. In 1998, it passed the Kirk-Flug Act, which withdrew baseball's antitrust exemption with respect to labor issues. But it expressly retained it for franchise relocation. We're going to talk about that next time. I don't know if you guys are familiar with a case called City of San Jose versus the Office of Commissioner of Baseball. We just settled this.
Oh, yeah.
Yeah, very much.
Yeah, we'll get into that next time. I don't want to talk about that yet because that's a whole other thing. I do want to talk about one last thing, and then I want to just mention Doug Gladstone's book because when I end the show, like I said, we're going to speak more than that. I'm never going to cover even a scintilla of your book because there's just so much to talk about. Now, let me just ask you this. Marvin Miller becomes the players rep, and I know how he went around, and they all voted for him. Why in God's name would the owners agree to an arbitration board when they had the players? Pick it up from there.
Well, I think there are a couple things going on there, and that was one of the great moves that Marvin Miller made was to get an agreement that arbitration could handle certain types of disputes. Now, the commissioner still had the best interest of baseball clause, and Bowie Kuhn would use that in certain areas, but he didn't use it ultimately in the Messersmith-McNally arbitration decision, which Peter Seitz, ruling for the panel that included Marvin Miller, would hold that the reserve clause, because in this situation they played that second year without being forced to sign a new contract. So Peter Seitz said the contractual relationship was done at the end of that second year. And that's, of course, a very real conversation because Goodell in the National Football League as commissioner has powers that really go all the way back to the way Landis established them when he took the position as commissioner in the 1920s. So I think Major League Baseball felt a couple of things. First of all, that they had something explicitly in the collective bargaining agreement that said it doesn't cover the reserve clause. So they thought that the arbitrator wouldn't have jurisdiction to handle that particular dispute. And then second of all, they thought federal courts would support them. And after the decision by the arbitration panel, which quickly resulted in Seitz being fired by the owners, then there was a case in Kansas City that Don Fehr was actually involved in as a young attorney and gets involved with the Players Association. as a result of that. And the court there says, much like the decision involving Goodell and Tom Brady, that there's a huge deference to arbitration decisions, and they're rarely overturned by courts. They stay as far away from getting involved in arbitration decisions as they can. So that covered a lot of ground, but the decision to create arbitration was critically important to what Marvin Miller was able to accomplish in the 1970s.
And Ed, don't you think that in more answering Ian's question, why did Major League owners allow this to happen, that perhaps the explanation was they had been on such a winning streak for so long, they were very, I think the word arrogant would be applicable here. They felt that, baseball was sacred and that it would be protected, that bad things would not happen. So sure, we'll go along with this, but we know ultimately we're going to win in court, or we're going to win wherever it's raised. I think another aspect might have been that they had lost a little trust in what Bowie Kuhn would do, and they thought maybe they wouldn't be so bad off if someone else, an arbitrator, made a decision rather than Bowie.
Yeah, I would go even further to say it was almost bordered on hubris. I don't think that they thought that they were going to be that they were going to lose any of the power that they had. Although this is agreeing to the arbitration predated the 1972 flood decision, but I think that's right. I don't think they felt like they were in any kind of trouble, despite the fact that there were attorneys for Major League Baseball that said that, we may be on shaky grounds in terms of the legal aspects of the reserve clause, and there could be, at any point, the Supreme Court could reverse field with respect to what it had held in federal baseball in Toulson.
Yeah, that's right. I mean, they relied on the courts, the magnets. But I want to leave you guys with this. And I'm going to end the show this way. I want you guys to hang on the line, because I always end the show and then I speak to my guests for about a minute or so, see how you like it and stuff. But I want to leave you with this. I know that we're going to continue on with your book. Do you guys want to come back also? I'm going to have Doug Gladstone on the show, I think November. I'll look at my calendar, 5th at 7 o'clock Eastern time, one of these days in early November. What I want to tell the people, because they've listened to my show, and they've listened to my producer show 2 weeks ago. He had him on as a guest. And what I want to do here is just lay out for you guys, if you're interested, to read a bit of Cup of Coffee, and it focuses on this. Since 1980, Major League Baseball players have needed only 1 day of service credit for health benefits and 43 days of service credit to be eligible for a retirement allowance. But those former ball players who played during the 1947 and 1979 seasons weren't included retroactively in the amended vesting requirement, and so receive, at the time of the book, no pensions. Now they receive a small stipend. But in going with this as well, what happens is that there is a person out in, his name is Ronald Dean, and he is an ERISA attorney, and he said that they can easily amend the ERISA laws on the agreement and literally grandfather these guys in, because when he spoke to Marvin Miller, Gladstone, he was very remorseful, saying he did overlook it. We don't know why that came to be. It's still a mystery, but I'm going to lay that out. It's up to you guys if you want to come to that show, and you don't have to answer now, but I'll let you bone up on it, on the ERISA laws as well as reading his book. But I hope you guys had a good time today.
Absolutely.
Oh, very much so.
I try to conduct my stuff like you conduct your classes. Scare the hell out of you. I'm not going to scare you guys. You guys are more steeped than I am in this stuff.
We're too old to be scared.
Yeah, I know. I mean, my nose is in the code all day, the Internal Revenue Code, and, of course, the baseball code. Hold the line, guys.
All right.
Okay.
Hold the line. Folks, I hope you had a great time. Go out. Get this book, Baseball Meets the Law. We're going to have Ed and Frank on maybe twice, I know once more before the holiday season. Go out. Get this book. It is so important. You don't have to read it cover to cover. It's a reference book. Open up to any page you're interested. You're going to learn something, and you're going to learn more about baseball, which is, as time goes by, unfortunately, a lot of this stuff is being overlooked. As always, I'm your host, Ian Kahanowitz, and thank you, Ed and Frank. And in the immortal words of Edward R. Murrow, good night, folks. Good luck. We'll see you next time.